Your Excellency, the Vice President of the Federal Republic of Nigeria, Professor Yemi Osinbajo, permit me please to stand on the remaining protocol that has been established by previous people who spoke in the interest of time. I want to welcome everyone, distinguished ladies and gentlemen, to this symposium event, which we are holding in honor of Bankole Olumide Aluko, SAN. The theme of the symposium, the ideal, our reality, and our potential in the context of justice administration, a subject that was very dear to Bankole Aluko's heart. I don't need to say too much about the importance of the theme. I think His Excellency did great justice to that subject. The importance of justice administration, His Excellency identified security, the economy, the rule of law, as being factors that make it an imperative that we should have a justice system that works. Talking about the ideal, I would point to one example, and that is the United Kingdom, from which we borrow a good part of our legal system. The legal services sector contributed £5 billion to the balance of payment situation in the United Kingdom in 2017. The legal services sector alone. And it was the professional service sector that contributed the most to the economy of the United Kingdom in that year. That's the potential. That's the ideal, and that's the potential. Now, in the context of a region, Africa, that is working towards greater economic integration, that should be our ideal as well. To be the international litigation powerhouse of Africa, the model, the place to which African countries go to resolve their disputes because you run an excellent justice system. Now, what is our reality? Again, His Excellency pretty much articulated that reality in his speech, and I will not go through it. If His Excellency was anecdotal in his approach, and if you wanted empirical analysis, just consult the Rule of Law Index for 2021, and the empiricals are there. The results are there in hard statistics. Out of a total number of 139 countries that were evaluated, Nigeria came 121st. Parameters being the civil justice system, the criminal justice system, we were very, very low on the ranking. And we need to say no more than that. Now, how do we get there? The panelists today are going to be taking a different approach to discussing justice reform. Practically everyone on this panel has been involved in some form of justice reform exercise or the other. And this panel will be sharing their experience with you and perhaps the knowledge, the realization that we need a new approach. We can no longer afford to continue to focus narrowly on the contents of laws or rules of court. It is time to begin a more fundamental appraisal and a sociological approach. One that says, let's look at the institutions, let's look at the players, and let's question their culture and their character. Because justice reform may not work until we begin to adopt an approach that questions the culture and the character of the stakeholders and the institutions. So today, to discuss this subject with me, this new approach to addressing justice reform, I have, in the order in which I will be putting my questions to the speakers, Mr. A.B. Mahmoud, Senior Advocate of Nigeria, and a former president of the Nigerian Bar Association, and therefore somebody who is in a good position to talk about culture and character among lawyers. Then I have, you're welcome, Mr. A.B. Mahmoud. Then I have Mrs. Funke Adekoya, Senior Advocate of Nigeria, partner at ALEX, and very importantly, in the context of what we are discussing today, chairperson of the Justice Reform Project, and therefore somebody who is also very experienced and able to talk about culture and character among judges. Mrs. Adekoya, very much welcome. I have Professor Fabian Ajogul, Senior Advocate of Nigeria, Managing Partner of Kerner Partners, and somebody who has a tremendous background in governance, and therefore very competent to talk today about the governance culture among the institutions that regulate both the legal profession and the judiciary. Professor Ajogul, you are welcome. Then I have Dr. Tunde Ajibade, Senior Advocate of Nigeria, Managing Partner of FCIArb and Co. And he's played a significant role and currently plays a significant role in the Nigerian Bar Association. He's currently chairman of the Nigerian Judiciary Committee of the Nigerian Bar Association and recently held a Justice Reform Summit in Abuja and has also chaired an effort to propose reforms to the Nigerian Constitution, and therefore someone who is very skilled and experienced to talk about how our Constitution impacts justice delivery in Nigeria. Mr. Ajibade, you are very much welcome. I have my Lord, Honorable Justice H.A.O. Abiru, an appellate court judge, a judge of the court, a justice of the Court of Appeal. And in that capacity, he sits, he presides over cases coming to him from the lower courts and is very much in a strategic position to see how questions of culture and character contribute to delays in justice and miscarriages of justice in Nigeria. My Lord Honorable Justice Abiru, you are welcome to the panel. Thank you very much. And then finally, on the panel, and joining us remotely from England, and I hope that the Zoom can pick him up, Mr. Paul Key, Queen's Counsel. Since one of the subjects we are discussing today is the ideal, and we are looking at the United Kingdom, in my introductory speech I talked about the contribution of the legal services sector to the UK economy. Mr. Paul Key is here. After he's listened to everyone on the panel speak, he will give us some insights into how the United Kingdom has been able to achieve the status of being a world-class international litigation powerhouse. Mr. Key, you are welcome to the conference, to the symposium. Now, I will go right into the subject and put my first question to Mr. Mahmoud. Mr. Mahmoud, culture, character, where culture is defined as the beliefs and attitudes about something that people in a particular group or organization share. And character is defined as the way that we are, all the qualities and features that make us different from others. Culture and character. And with specific focus on the bar, Nigerian lawyers. Can you identify briefly aspects of our culture and character which in your view impact the administration of justice?
Am I heard? Is it clear?
Yes, it is.
Right. So thank you very much, Tunde, for this question. And first, let me thank you for inviting me, yourself and Benga, of course, to participate in this very memorable occasion, honoring one of our very distinguished colleagues. And to sit to listen to, it's always a pleasure to listen to His Excellency the Vice President, and I've had the occasion to listen to him so many times in the last couple of weeks, whether it was at the Body of Benches event or at Bayero University or some other occasions. It's always on the spot. So to your question, I think it's very tempting to assume that there are particular aspects of our values or culture that would impede an administration of justice as lawyers. I don't really think there is anything inherent in a Nigerian lawyer that would impede that. I think for me, the primary problem would appear to be the regulatory framework and its inability to elicit the appropriate response or values from lawyers. Obviously, that is not to say that there are no aspects of our cultural norms or values, especially in societies like ours. When you sit in Lagos, it's sometimes presumptuous to talk about the Nigerian legal system without having a broad national understanding of it. The conditions do differ a lot, but it is true that for a lot of lawyers, when they participate as users of the system, their main approach or emphasis is often to see how they can influence, the process unethically, as it were, or take advantage. And we've heard through the Vice President many of these aspects of how lawyers take advantage of the system. But I think what we need to focus on is really how do we get a regulatory framework that will elicit the appropriate values and appropriate culture amongst lawyers. And as President of the Bar, we did do a lot of work in this field. In fact, I'm happy to say that some of the work that is currently being done, the National Assembly has taken root from that initiative. So what we tried to do was to show that we need to move away from the laissez-faire approach to regulation of the legal profession in this country. The legal services industry, in my view, is no less important than many of the other sectors that we pay so much attention in regulating, whether it is the capital market or the financial industry, pension, whatever, technology sector, telecoms. So we need to pay attention to how we regulate the legal profession. I think it is the Vice President rightly captures this when he says that the judicial resources are public resources. We as lawyers are merely custodians of it, who are supposed to or privileged to make use of it to further the public interest. But unfortunately, we have seen ourselves in a situation in which we do not perform this role. So what do we need to do? We need to go back to the regulatory framework. I think that the way the legal profession is being regulated in Nigeria today clearly leaves much to be desired. The primary regulatory body, as we all know, perhaps the body of benches, which is an odd 200 number persons that sits every now and again. I don't think that body is equipped to really regulate the legal profession in a modern economy. And one of the proposals we have, or we've made, is if you look at the current draft of the legislation that is being considered in the National Assembly, is to have an independent regulatory body and to reduce, or rather to make the body of benches more of a ceremonial body. But the real task of the detailed, meticulous regulation of the bar needs to go to much more independent, professionally run organizations. And we can draw lessons from the UK, which we like to make reference to often, like the Law Society Regulations Authority or the Bar Council's Bar Standards Board, both of which regulate solicitors and barristers, respectively. And when you look at the structure of these bodies and the type of work they do, they're very well-resourced bodies with a lot of personnel, with the capacity and the technical know-how. And law offices and lawyers are being regulated just the same way we regulate, other important players in the economy. So this is the culture we need to imbibe, and this is the direction in which we need to go in order to be able to elicit the appropriate attitudes and values. So lawyers know that when there are delays or when they take up cases that are untenable, that there are consequences. Now, so long as there are no consequences, you find this culture of lethargy and of taking advantage of the system. And I think this is where we need to focus our attention on. I hope I've responded to your question, Tunde. Thank you. Yeah.
Yes, the Nigerian Bar Association's Disciplinary Committee is the regulator of the Code of Ethics that we find in the Rules of Professional Conduct. Is that working well, or is it not working well? Is that why we are today talking about culture and values in the legal profession?
So unfortunately, the regulatory work of the Nigerian Bar Association is not being effectively carried out, as many of us know. When a complaint is made against a lawyer, you and I know that it may take anything between 2 to 3 years to really get to the root of it. Now compare this to the UK, for instance, where probably you have a time scale of 2 weeks, 3 weeks before a decision is made. So when you have, and this is part of the debate, whether in fact the regulatory function of the bar should be conducted by an independent body, apart from the Bar Association, aside from the Bar Association. Of course, there are many other issues that are involved with that. Some people would argue that this may undermine the independence of the bar itself. But I think we have to be able to draw a balance between the need to promote the public interest on the one hand, and the need to promote the independence of the legal profession, and to make sure that complaints by users, are speedily and effectively and swiftly dealt with. And so long as that is not achieved, the legal profession would be performing a very negative role, as far as the legal services industry is concerned. So we need to interrogate this point about what should the Bar Association be playing more of a membership role in terms of its responsibilities, or more of a regulatory role. And I think that perhaps some kind of balance will have to be drawn up somewhere.
Okay, thank you very much.
Thank you.
Mrs. Adekoya, let's turn to the judiciary, the judges. And, and I'm sure Paul Key will tell us later on about how a service culture, as opposed to a culture of authoritarianism, is probably one of the things that drives the culture on the judiciary in England. Integrity, for instance. Now, what would you say about culture and character on the bench?
Thank you very much. I would like to say that in my view, and from responses that we have received through participants in the Justice Reform Project, that there is a sense that, in fact, the culture of the judiciary is not as service-oriented as one would expect. The culture of the judiciary is also non-interventionist in terms of its proceedings. There seems to be a training or a belief that the judges should not descend into the arena. And therefore, lawyers get away with everything and anything. The judges are afraid, perhaps, of being petitioned against, or possibly worried that if they stamp out or snap down on a lawyer's participation, it would be perceived as bias or prejudice. And so that culture seems pervasive within the judicial sector. Judges do not want to, they are not in control of their courts. And perhaps because of the famous quotation which Justice Oputa made popular, but actually came from Associate Justice, I think it was Howard Johnson or Howard Jackman. We are not final because we are infallible. We are infallible because we are final. The judges have a sense of authority. And that seems to have resulted in some sort of insular thinking. We are in charge of the courts and we are in charge of the process, and are not open to new ideas, are not open to new precedents, new ways of thinking. You will immediately be told that foreign authorities are merely persuasive. We are not bound to follow them. And whilst I agree that we're not bound to follow them, there's nothing wrong in following them if the aims of justice are achieved in terms of interpreting sections of the law. So that's one issue in terms of the culture. Also, because the culture of the judiciary seems to be one of promotion. You behave well as a magistrate, you become a chief registrar, you become a judge, you go to the Court of Appeal, you go to the Supreme Court. There is a sense of do not rock the boat. If judges are slow to criticize superior decisions and often slow to even distinguish them, perhaps because distinguish them involves some level of academic rigor, which maybe they do not have the time for, or maybe they just do not want to be seen as criticizing a superior judgment. So that's part of it.
Yeah. I'm sorry to interrupt you, but you mentioned something just now. You talked about insularity. And I found that very interesting, and I actually wanted to look at it in a different context, and that's, in your role as chair of the Justice Reform Project, you've driven a number of reform efforts. One of them, for instance, is appointment of judges. And I know, for instance, that the Justice Reform Project is in litigation right now as we speak, yes, in relation to certain appointments that were done recently. On my part, for instance, I've also noticed insularity in the context of rules reform, for instance. In 2004, when you and I served on a rules reform committee together, we had a lot more involvement as the bar in trying to reform rules. But from 2012 onwards, in Lagos State, it's been a totally different story. Now, insularity in that context. Say, for instance, on the question of judicial appointments, how has that experience been?
I think in the context of judicial appointments, as I've said, there seems to be a culture of promotion.
Yeah.
And that therefore, if external appointments are allowed, because the Constitution actually does not regulate in terms of who can be a judge, other than post-call qualification. Yeah. But that insularity, that this is our turf, this belongs to us. You can't, if you want to become a judge, go to the High Court and start moving up from there. And I think the best years of the legal profession were the years when we had judges like Elias and others who are academics, who came straight to the superior courts. And this is what happens in other countries, and you bring a different perspective. You bring the perspective of the users of the service. Yes. And this is something else that I think where the judiciary can do something, yes, to see themselves as providers of services. It's not just lawyers, yes, who provide services within the judicial system. Sure. The judges are also service providers.
Okay. I mean, recently I saw an announcement from the Nigerian Bar Association calling for people to express interest in being appointed to the Supreme Court. Now, we've been here before. There was something very, deja vu about it.
We keep on knocking at that door, yes, and we keep on pushing that envelope.
Should we expect something different this time?
They say a pessimist is an optimist with experience. I think so far I'm not persuaded, yes, but hope springs eternal.
Absolutely. My Lord, Honorable Justice Abiru, you've heard Mr. Mahmoud and Mrs. Adekoya speak. You are an appellate justice, so cases come to you, and it will be interesting for our audience to know if, in these cases, you decide on appeal, you discern questions of culture and character intersecting with the administration of justice.
No, you see, good afternoon. Thank you for inviting me. I'm happy to be here. The key issue is, look, in any environment you are in, the culture of the people will permeate somewhat into the way you do things. Now, we're talking about rules and all that. I say, what I see from my own experience is that what you call character, to me, is actually more like attitude. Understanding your value system.
Yeah.
Because to be honest with you, at the end of the day, this job of a judge is, it depends on individual. What you see as the calling. Mr. Adekoya said something about service providing. I have always argued that the judiciary is a service provider. your services are no longer required, then you become useless to the people. I've always argued this fact that so the attitude and approach that we must have is that we are there to serve the people. Now, one thing that would drive your attitude and your understanding of how you go about your work, again, goes back to culture, the value system you have. When we grew up, we were taught that, look, hard work was the way to go. Doing things right and getting it done well was the way to go. Now, if that was what that was meant by culture, I agree with you that it plays a role in how you approach your work. If you know that you have, let me give you a personal example. I have a faith-based cultural attitude to work. And it is based on something I know in my region that, look, we're told that there are 3 types of judges. 2 will go to hellfire, 1 will go to paradise. And the 2 that will go to hellfire are the 2 that somebody who knows the work, understands the job, knows the law, but twists it. The second one is somebody who has no knowledge of the law, but pushes for the job and gets the job. And the third one is the person who knows the law and does the way it should be done. That drives my personal attitude to work. Now, so when you see judgments come from courts and you read through them, you discern where the person belongs in terms of attitude, approach to work, how the person approaches the work. You have matters in which trials go on for 5 years. They call 4 witnesses. It takes 5 years to do. It's not. There's nothing about cultural about that. It's attitude, understanding of what you're there to do. If you want to look, I'm a service provider. I have to do things that, will build confidence in the system. You know that doing a case trial for 4 years is not the way to go. So it's not. It's a lot individualistic. And when we talk about judiciary as a whole, don't forget we are individuals.
Yes.
Just one thing. Mr. Adekoya made mention of something just now. He said judges allow lawyers. They don't intervene. They don't get involved. And yes, and it's for good reason for some people. And I'll tell you why. And luckily the Vice President made mention of it here. When you intervene, you get petitioned to NJC. NJC calls you to come and attend hearing. You go with your lawyer, you go with your witnesses, you bear the cost of going there, you face the panel, and he says, no, there was no basis. You can go. You've lost sleepless nights. You've lost money. You've worried about, because, when you go to NJC, it's like your job is on the line. So you're worried. During that period, you are not stable. You go back, nothing. The lawyer goes home free.
Yeah.
So the point is that next time, why will I get involved and go through that stress?
Yeah.
Let me just let them do what they want to do. So it's it's a multi.
Let me illustrate an experience I've had, which I think reflects a cultural problem.
Okay.
Just yesterday morning, I was in court, and it was a case in which an ex parte order had been obtained against a client of mine 7 months ago.
Yes.
Specifically in August 2021. Ex parte. We applied to discharge in September last year, so 6 months ago. And the case has just been adjourned. So this ex parte order is still in force 7 months later. And yesterday I thought there'd be some remedy at last. And the beneficiary of the ex parte order, lead counsel, writes a letter to court and says, again, I can't come to court today because I lost a junior in my office. Now, when that letter was read out, because I'm aware of our culture,
yes,
we are very sentimental.
Yeah.
and sentiment drives a lot. I could not protest. I was completely handicapped about protesting because I knew if I protested, I would be seen as some kind of wicked, heartless, soulless person.
Yes.
But I'm sure that's not the culture in advanced societies. So that's our culture, sentimentality. Now, let me, just as an appellate judge, I want to put this question to you, sir.
Yes.
I think there's also sentimentality in our approach to understanding fair hearing.
Oh, yes.
Yes. And I would imagine that as an appellate judge, it's something you would have experienced a lot.
Yes.
We've actually interpreted fair hearing so sentimentally that we've now established an unjust and unfair system through our sentimentality. I'd like to know your perspectives on that point, sir.
I agree with you entirely. And let me just, on the issue of adjournment you're talking about, let me just give you an experience that I had. Some years ago, I went with the Lagos State judges on the annual retreat. I went to Malaysia. We met with the Chief Justice of Malaysia. We had a big meeting with him. And he said, look, in their system, cases from the High Court to the Supreme Court, 18 months. It's a maximum 18 months. 9 months in the High Court, 6 months in the Court of Appeal, 3 months in the Supreme Court. That is the... And we asked him a question. What about adjournment? And he looked confused. He didn't understand what we were saying. We said, what about matters not going on? And he said, why? Is it a national disaster? Is there a storm? Or, how? I felt embarrassed. Seriously. Because that is to show you the way they operate their system. The sentiments you're talking about doesn't work. You have, yes, you are correct. If you come to court and say somebody has died, it will be heartless of you. I mean, the judge even will look at you and say, what kind of human being are you? We're very sentimental. We are. But it's something that, look, we can better manage it. We can't wish it away. We can't wipe it away. We need to better manage these things. And say that, look, okay, if somebody died today, how many people do you have in your family? How many of them can die? I mean, it just the judge has to be firm, control the proceedings, and try and ensure that, look, I have a deadline. This case must not last 1 year. Whatever you do, put it within the 1 year, and then go ahead. Yeah. You understand? Yeah. So, culture will always be there, but we need to better manage it. We can't wish it away. It's part of what we have.
Thank you very much, my Lord. Professor Ajogul, as somebody who has a great deal of specialization in governance, I venture, not having, of course, the kind of experience you have, I venture to say, and I'm sure you'll correct me if I'm wrong, that transparency must be one of the fundamental tenets of a good governance system. Evaluating the institutions that sit at strategic positions, both in relation to our profession, the legal profession, and the judiciary. So the Nigerian Bar Association, the Privileges Committee, the body of benchers, the National Judicial Council. How would you assess culture and character within these institutions? Do they operate in an opaque way? Do they operate in a transparent way? If they do operate in an opaque way, is that important in understanding perhaps the effect they've had before now, or perhaps the lack of effect they've had up to this point on justice reform and justice administration in Nigeria?
Thank you very much, Leonard Silk. My short answer is that it's suboptimal, bordering on opaque. But my point of departure is to thank our big brother, Mr. Funke Oyebode, for putting up this. Anybody who's deep will know that this session means a whole lot to what we do as human beings, and I can only thank the partners of your firm for doing this. Now, I just want to say something about the discussion and then provide details. Whenever we've had this kinds of high-level discussion, brilliant ideas, and you all listen to the Vice President, Literally, I could just say I adopt everything he has said as my intervention because it covered the field, as we say. Can we think about a mechanism to connect the discussions we have here with policy changes as one major suggestion? Now, in terms of those institutions, why I said opaque is because there's a governance issue there. Let me give you an example. We need to separate adjudicatory functions from administrative functions. There's a presumption that a judge who has stayed long enough, worked hard, becomes the chief judge, must necessarily be a good manager of human resources, finances, operations, and so on. The fallacy is on the face of the statement. Absolutely incorrect. And so we find the chief judge battling with never really having managed things in terms of being an administrator, combining it with judicial functions, and the entire system is suboptimal, and what happens there is opaque. So for the judiciary as an institution, this is one key area we need to make a change in. And you find that when those functions are commingled, we find that it impacts independence in a way. For the very sensitive policy issues, you find that you might be at variance with the head of that court who already has all manners of powers in the way they carry on with being in charge of all that happens in a particular either state high court or federal high court or the court of appeal anywhere, or the Supreme Court, I dare say. Now, when you look at it, the impact it then brings out is one of implementing reforms. So it is not that we don't do the reforms. There's a reluctance. In the illustration you gave, those who sought to cure that situation where an ex parte order would linger for 6 months on multiple adjournments and some of them emotionally based, have said, if it is not heard within 2 weeks, it would vacate. There was a reason for the rule. I didn't make the rule. But that rule is observed in the almost, it's just not observed because another principle says it is still there hanging in the air until it's vacated. So why did we try to reform it in the first place? So that's an example of the reforms we already have not being taken advantage of. And so it takes me to the point about enforcement. When you look at enforcement in our system, of all of those reforms, of mechanisms that have been put in place to ensure a smooth administration of justice, they are again observed in the breach to a larger extent. So you find costs awarded that are in total departure from the reality of the naira. It makes nonsense of the idea of costs. You fly to Abuja, the case doesn't go on, and they award you 20,000 costs. Is that for the car hire or the air ticket or the hotel? I don't know. So, and then for those other institutions, the NJC, as was mentioned, and I wanted to mention something my Lord Justice Abiru was talking about. The presumption of innocence actually affects judges the opposite way when they're facing NJC. Because if you're a high court judge facing NJC and there's a promotion round coming up, we all must agree that we will drop this person who is facing NJC and consider the other candidates who do not have any cases at all. Now, so the NJC, the LPPC, those vital institutions to our system need to embrace governance in the sense of separating certain functions from the other for the sake of efficiency. And we don't need to reinvent the wheel. This is exactly how it's done in the jurisdictions where we're about to listen to. The topic of this session is our reality, the Nigerian reality, the ideal standard, and our potential. The topic actually separates what is going on. You can find that we're in the Nigerian reality, but we know that's not the ideal. And we know we've got a potential. So I think that's... Lastly, let me just quickly touch on technology and ethics, and that will be all. Technology, COVID is giving us a very good blessing on how to change our system. We have simply refused, in my opinion. I see no reason why we still take applications to regularize processes in open court. I see no reason why we're arguing preliminary objections and originating summons in open court. These things can be taken virtually, as most people are attending this event virtually anyway, and the people who say they don't have the technology to support it have access to data to forward meaningless videos on WhatsApp. So they can actually do it. It's possible. Then on the question of ethics, in a paper that I gave to the new legal year of Federal High Court to wear a couple of years ago, I talked about ethics at the bar and the bench, two sides of the same coin. Whenever you have found somebody guilty of some impropriety by the NJC, you wonder why there is no lawyer being held accountable, because they're two sides of the same coin. And so if we really want to carry out those reforms, we need to be able to hold both sides accountable. And that is the only message to the others about the importance of having a fair and straightforward justice administration system. Thank you.
Thank you very much, Prof. I mean, I totally agree with a lot of what you've said. I just by way of comment on, you did refer to the rule that had been laid down in the context of ex parte orders. The rule that had been laid down, and of course it was laid down as far back as Kotoye and CBN in 1988 or thereabout. I can't remember exactly, but it was laid down, and it's a rule that everybody knows. An ex parte order shouldn't last for too long. These are the standards on which you get an ex parte order. If it lasts for too long, it should be discharged. And at a point, the Federal High Court enacted a rule that sought to activate what was unquestionably a good principle. But a number of years down the line, it would appear to me that it was thought that that rule of the Federal High Court took power out of the hands of the judges. And so it was amended in a way that has had the effect that an ex parte order can last for interminably, which is what we experience today. Now, whether we see culture or character emanating in that kind of reform, quotes, is a question which obviously we will leave in the air for everybody to reflect on. Now, just before I turn to Mrs. Funke Adekoya again for another follow-up question, just an announcement to the audience, just in case anybody is interested in posting a question on the chat group. There's a chat box on the Zoom facility with which some people are joining remotely, and you would all have received the links to that same chat group. Secondly, there's a Slido facility, which I understand can be put up on the screen right now. If you just download Slido on your devices and quickly make a note of the code there, 364858. 364858. You can also enter questions in the Slido app, and if there's enough time, we'll be able to put those questions to the panelists. 364858. Thank you. Now, I'll turn to Mrs. Adekoya. Now, Mr. Mahmoud considers it to be a regulatory issue. You've identified cultural issues. My Lord Justice Abiru has identified cultural issues, sentimentality, and he says we just have to find a way to manage it. Professor Ajogul has identified a culture of opacity in the relevant institutions, which is not optimal. First question, is justice reform meaningful if culture and values are not addressed? And my second question would be, if it is not meaningful, as I would suspect the answer is, then what is the best strategy for addressing culture and values My Lord Abiru talked about managing it. Perhaps you can shed some more light on how best can we drive. Do you agree in the first place that now maybe we should turn our attention from the contents of laws and rules to the content of people's character and the cultural norms of our societies?
I agree that we can't have justice reform without addressing culture and without addressing character issues. In the way in which you've defined the culture of the sector and in the way in which you have defined the character of the sector. And the Vice President answered the question. In fact, when he said it, I'm like, somebody else is hearing. Costs. If I were the judge in your matter, I would have adjourned the matter so as not to be heartless. But I would have awarded substantial costs. And until we can change that character, I've been before a judge where the opposing counsel said, I'm only here out of deference to your lordship. I'm not feeling well. And from here, I'm going straight to the hospital. But it's just because he's my lord and I'm very... And he was a senior colleague in age. And so as not to be seen as a monster, I told the judge, my lord, I concede to my learned friend's adjournment on the grounds of medical ill health. But I'd like to raise 2 points. The first is that, my lord, you sat at 11. We've both been sitting here since 9 o'clock. My learned friend never told me, I'm only waiting for the judge to come, then I'm going, or I'm not well. This is the first time I'm hearing of it. If you had written me a letter yesterday, which is the ethics of the profession, I would not be here. I would have sent a junior. Because he didn't write me that letter, I am here in court today, my lord. I am here with my junior. We have incurred the following costs. My hourly rate is XYZ. My associate's hourly rate is XYZ. We've been here since 8:30. It is now 11:20. This and this is what we've done. And my lord turned to the law students who are present in court and said, this is how an address should be made when you are asking for costs. You can't just ask for money without substantiating it. I want you all to take note that when you are asking for costs, you must give the reason. And then my lord turned to me and said, costs in the cause. So unless we change the culture, we cannot have those reforms.
Okay.
One of the ways of the reforms is costs.
Yeah.
Costs, and the rules allow for taxation of costs. Let's implement that.
Yeah.
Costs on a full indemnity basis. Not 50,000 for going to Abuja and having the matter adjourned.
Yeah.
Or 50,000 for coming to court.
Yeah. Thank you. I see that's a very popular suggestion. Thank you very much. Dr. Ajibade.
Could I just say one more thing?
Yes.
And in the same way in which we file an affidavit of compliance when we pay late filing fees for filing processes late, when costs are awarded, the person against whom the costs have been awarded should file an affidavit of compliance that those costs have been paid before the next adjourned date.
Okay. Thank you very much, Ms. Adekoya. Yes, indeed. And indeed, costs is one of the things in the Administration of Civil Justice Bill that the Justice Reform Project is pushing. There are comprehensive provisions to reform the cost system. Unfortunately, again, probably going to the insularity that I think my Lord mentioned, we've met a lot of resistance in trying to pass that bill. But did you want to comment on that?
I just wanted to say something.
Yes.
The resistance is because people say access to justice.
Yes.
If you award high costs, you are stopping people from coming to court. Is
that sentimental?
It's not only is it sentimental, it is incorrect.
Yes.
Because if the costs are awarded in favor of the person who has incurred those costs, there's no access to justice issue.
Yeah, absolutely.
Invariably, you find out that clients pay transportation costs to the lawyer.
Indeed.
If the lawyer gets his costs from the other side, the client benefits at the end of the day. There's no access to justice issue at all.
Okay. Thank you very much, Ms. Adekoya. Dr. Ajibade, you chair the MBA's Judiciary Committee, and in that capacity, you've presided over a process for drawing a bill to amend the judicature provisions of the Constitution. And you also recently hosted a summit in Abuja where you addressed 3 principal themes that you had identified as problems with our judicial system. The first was judicial appointments and selection. The second was budgeting, funding, and accountability. And the third was accelerating the speed of justice delivery. Now, reflecting on those broad themes in the context of this discussion about culture and values, character, do you perceive that these problems that your committee has flagged as important for consideration are driven by cultural issues? Any one of them, or indeed all of them?
Thank you, Tunde. Well, first and foremost, just like everybody else, I must start by congratulating Aluko Oyebode for putting this wonderful event together in honor of a very great man, late Bankole Aluko. Culture, as all the panelists have mentioned, I think is clearly an inseparable part of the challenges that are confronting our justice sector. And it's something that we clearly need to address. But I personally, I think that the challenges confronting our justice sector are so deep-seated that we need to attack them from every angle. It's not just culture is one problem, but there are also structural challenges. And it was with that in mind and realizing that there was no way in which we could address all the problems in one summit or even in one term of any NBA leadership, that in organizing the Justice Sector Summit that we organized a couple of weeks ago, we tried to identify what we consider to be the foundational problems. And His Excellency the Vice President, I mean, not only was he there, he gave us full support, but in his keynote speech, he's identified some of those foundational problems. And one of them is appointments. But listening to everything that has been said, especially when you take into consideration that we're talking about a profession, I always try to emphasize the fact, and it bears repeating, that nobody was ever called to the bench. Judges are lawyers. They were lawyers before they became judges. So it's a problem with our profession. So even going back, let's take it back beyond judicial appointments. I think we have a problem even with the people that we're admitting into the profession these days. I think there's an insufficient appreciation of the role of a legal professional and the qualities that a legal professional needs to have. That is the first stage. That is even to become a lawyer. And I'd be interested to hear what Mr. Key has to say about that, because I think the bar here is just too low. But then to cross that bar, one, you become a legal practitioner. To cross that bar and then become a judicial officer, to my mind, means that you're going to tick even more stringent boxes. And His Excellency the Vice President again mentioned it, that to become a judge, a judicial officer of a superior court in the UK, you go through about 17 different tests. But here we say, 10 years post-call, you can become a judge. It doesn't even say 10 years of practice. Just 10 years post-call, so you could have been 10 years as a hairdresser or a barber. And once you're a lawyer and you spend 10 years, if you know the right people, you push the right buttons, you become a judge. We cannot address the challenges in our system if we don't address that critical point. Because we've also spoken about the inability of the courts to impose the right level of discipline on practitioners. That presupposes that the judge himself or herself appreciates, the ethos, the role that they're playing in society. So we identified appointments as a foundational problem. We have proposals that that were put to that summit. You were in attendance, which we're going to push very, very vigorously. Because I think one of the problems, we're also so jaded now in our profession that people say, we've heard all this before. You have summits, you have conferences, and we don't see any output. This one we're going to try as much as possible to make sure that it's different. But then it's not a one-sided thing. Again, as His Excellency said, you talk about appointments. There are other factors that conduce to the relatively poor quality of appointments. And the late great Bankole Aluko is a very good example as well. We've heard it today, that his initial ambition, his life ambition was to be a judge. But that when His Excellency was in a position to invite him to the bench, he came to the realization that, it's too difficult on that side for me to leave what I'm doing now and to become a judge. So we can't complain about the quality of our justice sector if we also don't address the inadequacy of the welfare of our judicial officers. And that is why we selected our second topic, which was the funding, the budgeting, and the administration of the courts. Because the truth is also, if you listen to the statistics, we're in a country of 200 million people and we have just over 1,000, definitely not 2,000 judges of our superior courts. We're not anywhere close, it's just over 1,000, I'm told. Now, how do you expect just over 1,000 judges to administer justice effectively for 200 million people? It's almost like we're not serious. If we, again, our reality and our potential, if we compare what we have per head, per capita of the ratio of judges to citizens, we find that we're way behind the curve. And you cannot appoint the appropriate number of judges if you're not prepared to put more resources into the justice sector. So if we continue to complain without addressing that fundamental problem, that we need to put more resources, serious resources into our justice sector, then we're not serious. And the blame for this is not just for the executive, as far as I'm concerned, also the judiciary and the bar has not done enough to fight this corner and fight it effectively. Yes. And then, of course, the third, which we identified, is delay, which is just a consequence of the first two. I mean, if you have a poor quality of judicial officer who is poorly remunerated, who's overworked because there are too many cases for too few judges, of course, the obvious consequence is the backlog we have in our courts. Yes. And the CJN reeled out statistics that showed that it's not going to change if we don't do something drastic, because the cases are being filed at X speed and our disposal rate is X minus about 80%. So the situation is going to continue going from bad to worse, except we get serious and address the problem in a fundamental way. Now, some of the changes that we've addressed, as I said, there are cultural problems, there are structural problems like the need for increased funding, etc. But then there are also simple things that we can do to address the problem. We identified quite a lot of them in the proposals we made for constitutional reform. One, which is my favorite and which is something I've been pushing for upwards of 15 years, is the amount of time we spend litigating about where to litigate. It is such a simple solution. We still have, in this day, the Federal High Court was established in 1976. We still have cases going to the Supreme Court where you are having arguments about whether it was Justice A in the High Court or Justice B in the Federal High Court that has jurisdiction to determine the matter. When the qualification of Justice A and Justice B is exactly the same, 10 years post-call. So you're not arguing about the quality of justice you're going to get. You're just arguing about a technical tool that we all use it, if truth be told, that every lawyer who has a difficult case latches onto to challenge the jurisdiction of the court, because that immediately ties up the case and takes you all the way to the Supreme Court. Now, we can solve that by inserting a provision in the Constitution saying that all the courts of concurrent is not the word, of coordinate jurisdiction, all the superior courts of coordinate jurisdiction, if their jurisdiction is challenged for any reason, then the Constitution should authorize them to transfer the case to the appropriate court. You can't come to the court and say you don't have jurisdiction, it's another court that has jurisdiction, and use that as a reason for tying up litigation for 10, 12 years, which is what is happening today. If we put that provision in the Constitution, which is one of our recommendations, and it's the one that I consider to be most significant. There are a lot of them. I mean, the bill that we've sent to the National Assembly is a 31-pager. But this one, I think, will unlock quite a significant amount of the delay. That's apart from all the other important things that I think need to be done. Okay. Thank you.
Thank you, Dr. Ajibade. I will come to, I'll come to Mr. Paul Key in a moment, but I wanted to challenge something. Yeah, you did talk about culture as being just one aspect. I'd say it actually runs through a lot of things. Within ask a question, for instance, are we getting the best that we could get? And if we are not getting the best that we could get, is that because the process is opaque? Going back to questions of culture.
The opacity in the process clearly is a challenge. And I try to address that, like I said, right from the inception. Yeah, right from the inception, even from who becomes a lawyer. That is a cultural problem. We have allowed our culture to devalue our emphasis on merit in every sphere of human endeavor, and that is a challenge.
Thank you, Dr. Ajibade. I'll turn to Mr. Paul Key now. He's been waiting because he was going to understand the context. And Mr. Paul Key, at the beginning, I talked about how much the legal services industry has contributed to the economy of the United Kingdom. You've heard everything you've heard so far. What are the lessons you think Nigeria can learn in terms of culture, values, and constitutional arrangements to be able to achieve the kind of ideal that the United Kingdom has achieved? Paul.
Thank you very much, Your Excellency, distinguished guests. Thank you very much for the opportunity and the kind invitation to speak with this wonderful tribute to your friend and colleague. I think it's fair to say at the start that England, the United Kingdom, is not perfect. We are all in our own ways finding our way to improve the quality of justice. To the extent that England has achieved anything, it is in part, I think, due to a culture of always seeking to improve. Things are not static. The processes are always being considered and reconsidered. And it's therefore heartening to hear that you in Nigeria are undergoing the same ongoing process. I have three general topics that I can briefly discuss. I won't take long. The first is the use of committees where stakeholders in the administration of justice have an opportunity to exchange views. That's item one. Item two is what happens from the advocate, counsel, law firm side of things. And topic three is what happens from the judge side of affairs. So firstly, on the committee side of matters, there are formalized and non-formalized committees in England, the United Kingdom, and the Commercial Court Users Committee is a good example, where various individuals and entities who are interested in the administration of justice get to exchange on a full and frank basis what they think is going right and what they think is going wrong. And these are public debates. So if one wanted to look at what happens, one could type in Commercial Court User Committee, and you would see the minutes of the last meeting, and indeed all the meetings. And the people who take part are judges, there are barristers, the counsel, law firms take part, significant clients if they want to, such as clients meaning institutions and entities which use the courts a lot, such as banks, oil and gas companies such as BP and Shell, or mining companies, and other interested parties such as those arbitration institutions. who feel they need to have some input and provide a means to tell the judges what they see as going right and going wrong. And that really provides a basis where everybody is treated equally in terms of what they have to offer and what they can say at the committee. The judges are not speaking from a higher position. The judges are just there to provide their views on the difficulties that they are facing in terms of advocates doing certain things and not doing certain things. Counsel can say that, you know, it's very slow to get judges back hearing cases, and we're having to wait long times for judgments. It provides a very good mechanism whereby everybody can understand what is going wrong and how things might be improved. And a lot of the very serious and far-reaching reforms have been achieved through these committees. The committees are just, they're not appointed, so to speak. They are, one can write in and say, I would like to be part of this committee, and almost inevitably you'll be allowed to be part of the committee. So there is no protective shell which stops people becoming part of that committee. And as I say, it's not a process whereby you get special access to the judges, not at all. The judges are as much under the spotlight and criticised as much as anybody. So that's the committees. The second is what happens as regards advocates and more generally law firms. And there is both a carrot and a stick series of events which impel counsel to behave in the proper way or the desired way. So when I say carrot and stick, I mean carrot meaning incentives are provided, and the stick is disincentives are provided from acting contrary to these ways. So the sticks are many and varied. And what I sense from hearing the earlier speakers, and it's been very interesting to me, is that the sticks are not anywhere near as severe in Nigeria as they are in England. And to give one example, there was some discussion about the ongoing difficulties that apparently are faced in some cases in Nigeria about counsel or advocates at a last minute declaring that they are unable to proceed with the case on that day because of illness, because of some family death or otherwise. Well, in England, that almost always does not happen because you just need to get a replacement counsel. There is no protection, no ability for a client to say, I want this counsel and I will only have this counsel and I must have this counsel. If someone turned up and said, I am counsel and I am sick, the judge might say, well, we don't understand why the client didn't get a replacement counsel. If you only became sick this day, fair enough, but we're going to have the case heard tomorrow and you must get a replacement counsel and we're happening tomorrow. So there's no ability for people to postpone a hearing by manipulating or otherwise counsel's availability. The sticks include cost orders. That's cost orders against client, but also cost orders against the actual advocates. If the advocates do something wrong, they will be asked and ordered to pay out of their own pocket. There is no qualms about counsel being publicly admonished in judgments. So regularly, judgments will come out where a counsel is severely criticised in this public judgment for what they did or did not do. The judges will quite regularly refer counsel to the overarching professional conduct committee, which is run by the Bar Standards Board, for investigation if they think the standards have fallen short from that counsel. There is an obligation on counsel to self-report for serious misconduct, and there's an obligation to report other people for their serious misconduct. So if I observed in court someone's serious misconduct and I did not report that, to the relevant professional ethics committee who can sanction the council, that failure by me would itself be serious misconduct. So that the list goes on and on. There are many and varied sticks. The incentives, and just to round off the stick aspect. The stick aspect ultimately leads to the conclusion that as council, we, in some senses, so live in fear of the terrible things that might happen to us if we don't act properly, that we don't even think about acting improperly. It just would be, in some senses, either inconceivable or a very, very, very dangerous game to play. In terms of the sticks, to advance through the career path, and in particular to become Queen's Counsel, one needs to demonstrate that, and by judicial referees who provide some independent report, one needs to demonstrate that one has observed fully all the standards of ethics and professional obligations that would be required of a senior member of the English bar. And of course, judges likewise will begin to make it clear that they trust certain barristers because they play by the proper rules and don't try to take shortcuts or do inappropriate things. That's the advocate, and that also applies to law firms. In terms of the courts, just briefly on the courts and the judges also have a number of sticks which are held over them. So each court will have a judge in charge of that court, and that judge monitors the time taken by judges to render their judgments. The judges are expected informally to get through a certain amount of work, and that amount of work means hearing the case and giving a judgment, which is not just an adjournment judgment, and it's not just that's very difficult, I should go to another judge. It is a substantive judgment. And those various metrics are always noted by the judge in charge of the list. And if there is some problem, the judge in charge of the list will not hesitate to make it very plain to the judge who's falling behind on those metrics that there is some serious problem and things have to improve.
Yeah, Paul, thank you very much. I'm so sorry, yeah. we are really running out of time now, and I'm sorry I have to stop there. There are so many questions I'd actually would love to put to you by way of follow-up, but unfortunately, we have run out of time. We unfortunately also will not be able to take, there are lots of questions on the chat facility. What will happen is that we will take note of those questions and endeavor as much as possible to send responses to the people who have put those questions across. Paul, thank you very much for joining us, and I'm sorry I had to interrupt you midway. I also want to thank our panelists here in the room, Mr. Abi Mahmoud, Professor Ajogul, Mrs. Adekoya, my Lord Justice Abiru, and Dr. Tunde Ajibade. Thank you for patiently listening. I think we certainly have identified culture and values as something that we have to put on the agenda for justice reform, as indeed I would imagine reform in every other sector of our national life that needs reform. Thank you very much, and I will at this point